Dear professors, dear speakers, dear guests, in the name of the Faculty of Law of ELTE University, I would like to warmly welcome you at our conference, Legal Aspects of Blockchain and Digital Assets. Although the title suggests that legal aspects should be in focus, if you look at the program, you will see that today's lectures were meant to be interdisciplinary, because this is the only way such topic might and should be approached. This is because law appears to play a kind of adaptive role in relation to technology. It reacts retrospectively or prepares the ground for it. But in order to do so, law must be able to assess the main characteristics of technology. Digital computers have been around since the late 1930s, so we can now speak of the digital age and the age of information technology. General-purpose computers have been on the market for more than half a century, and we will soon be able to say the same about cellular networks and robotic technology. The challenges that the spread of digital technology poses to legal scholarship and practice are obvious. We often use the word disruptive to describe new digital technologies because they fundamentally change the existing framework, and we have to rely on to protect values such as private autonomy, property, privacy, and trust. The context has changed with regard to consumer protection, property law, contract law, banking and finance, and other areas that are the focus of this conference today. However, disruption is not necessarily a bad thing, just like crisis. It is an opportunity to consider the need for and possible way of development and reform. Legal frameworks and policies should be revisited and reconsidered. Fundamental questions of law will be opened again. The concept of property, the legal nature of data, the concept of money, vulnerability, the legal effects of digital forms of communication, the role of written forms, transferability, consent, and decision-making in human-AI cooperation. Since the 1960s, legal scholars in Hungary have also been involved in the discourse of technology regulation. For example, Professor Imre Sárándi published an article in 1972 entitled "The Scientific and Technological Revolution of Legal Science." Over the past 15 years, we have encountered a number of challenges within the regulatory framework. Firstly, it has become evident that the regulation of technological issues is crucial for the shared development within the European Union. On the other hand, we had to consider the risks posed by technology, ranging from data or images falling into the wrong hands of an individual level, to sovereignty being at stake at the other end of the scale. Finally, constantly changing and evolving technological environment requires increasingly frequent reviews of and amendment to regulations, as recognized by the European Commission's new digital strategy. The endeavor of the EU to be among the first to legislate in these fields resulted in a number of regulations called ACT, similarly to the US federal acts. AI Act, CHIPS Act, DSA, DMA, Critical Raw Material Act, just a few abbreviations from the recent times. The regulation of technology encompasses hundreds of legal norms, an even larger body of legal documents, and a vast array of standards. They must be incorporated into the standard teaching curriculum. If we compile a list, we will find that there are approximately 40 fundamental European legal acts relating to technology law, which students should be familiar with. Therefore, dealing with the legal aspect of technology within the general education is essential. This is why I am particularly proud that today's conference is also the launch event for our newly established Department of Economics and Legal Technology. Never a worse start. In the light of this, I wish you a valuable and useful conference, rich in meaningful exchanges of thoughts. Thank you for coming, thank you for being here.